Hey everyone, it's Kara Williams with Williams Immigration, a boutique immigration law firm where we help business owners and entrepreneurs and families navigate our U.S. immigration system. I work with clients all over the United States, so in all 50 states. I also work with folks that are international, so that are not currently in the U.S. For my business owners, my managers of businesses, when you all have identified that perfect candidate that you want to hire and that person happens not to be a US citizen, you can come work with my firm and we can make sure that we get the right work authorization on board, the right work visa, and do all the compliance around that. Also help you think about how to sponsor that employee for a green card down the road or immediately if you want to do that as well. For my family-based clients, usually it's going to be a US citizen or a green card holder who wants to sponsor a family member for their green card. That family member is usually going to be a spouse, a fiance, a parent, or a child, a dependent minor child. Dependent children in the immigration system are anyone that is under 21 and unmarried. So if you are 20 but you are married, you are no longer a dependent in the eyes of immigration. So you want to keep that in mind. Excuse me, y'all know I'm still trying to get over this cold situation. So I will certainly answer your questions in a very general way. I am a lawyer. I'm an immigration lawyer. I'm a former USCIS Adjudications Officer. While I am a lawyer, I am not your specific lawyer, so I will not be giving you any legal advice for your specific case. Everything that we do on lives is educational. So if you want advice pertaining to your specific situation, your specific set of circumstances, you are welcome to work with a firm. The way that you do that, all our engagements begin with a consultation. You can click the link in my bio and get yourself signed up to have a meeting with me, a one-on-one meeting. And then we talk about what's going on in your specific situation. I ask you a ton of questions so that I can get a good understanding of what's happening. And then we talk about a strategy to get you where you want to go. So because it's educational, I like to kind of pick a topic and just kind of educate y'all a little bit on it. And then we kind of dive into questions. So tonight I just want to talk about real quickly what government agencies touch your immigration file. I feel like we talk about, immigration is an alphabet soup. We throw out all these acronyms, all these abbreviations. And if you're new to immigration or you're in the middle of it, and you're just not quite sure what's going on, and sometimes you can't follow a conversation, I think it's helpful to know what agencies touch your case and what those agencies are doing. So because my practice is a lot of employment-based immigration as well as family-based, we're going to start with employment, talk about those agencies. We're also going to talk about the agencies that touch a family-based case. So for an employment-based case, the U.S. Department of Labor can have a part in that case. The U.S. Department of Labor will give us prevailing wages, which is the wage that we need to be paying the beneficiary or the employee when they are going through the process. The Department of Labor, when we are, applying for a green card, an EB-2 and EB-3, the Department of Labor looks at whether or not we have done the proper advertising. They tell us what the wage rate is. So Department of Labor is intimately involved in some employment-based cases. Now that could be the federal Department of Labor. It could be the state Department of Labor. So we definitely deal with, Department of Labor. For an employment-based case, and Department of Labor doesn't really have a role in the family-based cases. So now for both family and employment-based cases, we work with USCIS, which is United States Citizenship and Immigration Services. they process the applications. They're the ones that, tell us, hey, you haven't given us enough information. Here's a request for further evidence or an RFE. They're the ones that issue our approval notices. So they're the ones that are looking at the application and determining whether or not we qualify for whatever we are asking for. Whether that's an approved I-130 on a family-based case, whether that's an approved I-140 on a business case, immigration, USCIS handles EB1, extraordinary ability, EB2, national interest waiver. In the local office, in your state or in your town, they will be the ones who conduct the interviews for the family-based cases. So they'll be adjudicating and processing your green card application. That's who you'll talk to for your interview. And then if you are overseas for both employment and family-based cases, we will deal with the NVC, which is the National Visa Center. It's really, I call it a clearinghouse. It's a liaison. In my office, it's the liaison between myself and the consulate. When we are gathering those last bits of information to submit to the NVC, and then the NVC works with the consulate to get us an interview scheduled. So the NVC, although it's not a standalone government agency, it works very, very closely with the Department of State, right? And so they are an integral part of that process. The Department of State oversees all of the consulates and embassies for the U.S. out, overseas. So Department of State has a huge role in that everybody who either on an employment-based case needs to get a visa. If you're a student, you're overseas, you need to get a visa, you need to go into the consulate. Those are overseen by the State Department. So that's sort of the world of the government agencies. So for an employment-based case, it's often necessary that I am working at any given time on your case with either the Department of Labor, USCIS, or NVC. The other agency that you deal with when you're coming into the country and you're at the airport, you're dealing with Customs and Border Protection. So those folks are looking to see that you have the right entry documents, right? So keep that in mind. You are dealing and working with a lot of different government agencies that all work together. I can tell you they all work together because when I worked inside USCIS, I worked with my counterparts at these other government agencies. So there is agency cooperation. They do know what the other one is doing. They're not operating in these separate silos. So keep that in mind. But I thought it would be helpful if you all knew what different government agencies you could come in contact with, depending on the type of case that you would have. And know that at my firm, we deal with these agencies and communicate with them all day, every day. So if you have questions, you are welcome to put them in the chat. Let's see what we have. And then honestly, how long I stay on this evening really kind of depends on how many questions I'll have. So it's totally up to you until, of course, I get hungry and then I got to go make some dinner. Let's see here. My U.S. citizen wife filed an I-130 and received by Texas Process Center in September 2021. Okay. I don't, is there a question? That's just kind of a statement. So, oh, okay, here we go. We still didn't get any update on it. It's 24 months, normal period of time for processing. It could be, it sounds a little long, but it could be. Processing times depend on the type of application that was filed. So, and the office that is currently processing. So it is not simply that you have an I-130. It is the classification of I-130. Are you an immediate relative? Are you first preference, second preference? Like, where are you in those preference categories? That will depend on how long it takes the Immigration Service or what their expected processing times are. I don't have enough information to tell you that, but you can go on the USCIS website and look and see what their current processing times are. And they force you now, they didn't used to, they force you now to drill down into your case. So they will ask you, is this an immediate relative case? Is this a first preference case? And they don't use those words. They make it very easy. So you can look online. That's kind of the easiest way to do it. You can certainly set up a consultation with us to do that for you, but you're probably going to be fine looking at it online. And then if you've got questions based on that, we can certainly talk. Sometimes cases take a long time, period, plain and simple. Sometimes cases get lost. Sometimes you're waiting too long, and then we need to sort of push the government, right? Some folks file in federal court. Some folks get congressionals involved. So it really just depends on the facts of your case. Okay, so I hope that is helpful. Although I know it doesn't give you the exact processing times. If you have a receipt notice, they'll tell you, what stage your case is in online, again, on USCIS.gov. Let's see here. Down on the slow scroller. So what else do we got here? Does USCIS look at past visitor visa applications before they approve an I-130? They certainly can. I have a feeling, based on the question, that there is more to that question, which is fine. But USCIS can absolutely access, and if they think they need to, they will access data about you. So they will look at publicly available information. They will look at, prior visa applications. They will do background checks. And I-130 leads up to a green card. So they will absolutely do whatever background checks they think they need to do. If there is a certain concern that you have regarding prior visa applications that you think may potentially negatively impact your I-130 and your green card application, I would say click the link in the bio and get yourself a consultation, and we can talk about it in depth. What else? Why has the estimated time changed to your process take more time than estimated? Not quite sure I understand the question, but I think what you're asking is, why do processing times change? Processing times change because workloads change in offices. They change because people take vacation, right? They change, and I'm being serious about that. I'm not being flippant about vacation. Towards the end of the year, a lot of individuals who work in the government have what we call use or lose time. They're not going to lose their vacation time. They're going on vacation. That happens every year. So typically during the holidays, most people start to slow down a little bit. They're getting into the holiday spirit. Happens in the summer as well. Kids are out of school. People are taking vacations. They're taking time off. Processing times typically tend to slow down in the summer and towards the end of the year for the holidays. Because these adjudicators are humans and they want some time off. They want to spend time with their families. They need a break just like everybody else. So processing times will slow down. Processing times now are very, very fluid because the Department of State, through the consulates and the embassies, as well as USCIS, are digging themselves out of a massive, massive backlog. So they are transitioning work to different service centers to try to even out the workloads so that things are moving and progressing forward. But processing times are going to change. Processing times are not fixed. Processing times move. So I hope that answers your question about processing times. Let's see here. My first interview was a Stokes interview. Is that a good or a bad thing? So a Stokes interview, for those of you who are listening who may not know what that is, a Stokes interview is essentially when there is an immigration case at the local office. It's a family-based case. It's a family-based green card case, which means a family member has sponsored you. A Stokes interview is where you are separated and you are not interviewed together. So the officer will have one person wait outside. They will ask questions. Then they will basically have you all swap places. Second person will come in. They will ask the same questions. The officer will look at the answers, and if they are, significantly the same, not a problem. If they are significantly different, that's a problem. The officers where I have been in Stokes interviews, they have said right then and there during the interview, your answers are all sorts of off, right? So a Stokes interview doesn't have to be a bad thing if that's your first interview. The Immigration Service can certainly decide that they want to do, a certain percentage of Stokes interviews for the first interview, just randomly. Or there could be something in that file where they want to get to the bottom of it. Ultimately, the interview, whether it is a Stokes interview or not, is designed to ensure that everybody's telling the truth, that no one has filed just to get the green card, and that this is a real relationship. It is a real existence. So could be a good thing, could be a not so good thing. When I've had Stokes interviews, the officer has told me right then and there as counsel with my clients present, what questions were the same, what questions were different. So I don't know in your particular case, but it does not necessarily have to be a bad thing. If the officer wants more information, they will request more information. Excuse me, after that interview, and they'll do so in writing. So you'll certainly have an opportunity to respond. We have an approved I-130, but the beneficiary is worried that they will deny at interview. I'm assuming the green card at interview, based on denied visitor visa. Depends on why the visitor visa was denied. I have no idea. A case could absolutely be denied during, at the interview stage. But again, I would have to know what your concern was about the visitor visa. So I would say that for that, you really need to schedule a consultation. How long are CR1s taking? I don't know. Every single time my clients ask me for processing times, I look them up individually, specific to their file. Processing times are fluid. Processing times depend on the type of application and the office processing that application. Different offices have different workloads, which means that their processing times are going to be different. So the short answer to your question is I don't know, because I haven't memorized all the processing times. And again, processing times, y'all, are very, very fluid. But I will say, every time I go live, I get a lot of questions about processing times. I think there are many benefits to working with an attorney on your case. One is, I think, peace of mind, cuts down on the amount of Googling that you feel like you have to do. But my clients are provided processing times. They know what their processing time should be. If there's something significant that happens in the immigration world, change in policy, change in law, I'm reaching out to them and letting them know what I think that change will do, if anything, to their processing, to their overall processing times. So I think that is certainly one of the benefits of working with a law firm on your case, is that some of these questions, they just automatically answer for you, because we know that that's one of the things that our clients are interested in and concerned about. If they ask for more evidence and medical, is that good or bad? So medical tells me we're talking about a green card application. Asking for more evidence is just that. It is the Immigration Service saying we didn't get enough. We don't think we have enough here to make a decision. And we're giving you an opportunity to give us more information. I think of requests for further evidence as gifts. Not all immigration attorneys think that way, and that is totally fine. I think they are a gift from the agency, because what the agency could have done is simply denied your application, or they could have given you a notice of intent to deny your application, right? But by them giving you a request for further evidence, they are giving you an opportunity to give them additional information. So I always tell my clients, we're going to take the opportunity, right? We're going to take the opportunity that has been given to us. I've been doing this for a while. I can generally read between the lines of an RFE and see what what they're asking for, what the problem is. I don't know what they are asking. I don't know what evidence they are asking for. A medical is a very straightforward piece of information. Go get your medical done, send that in. I don't know what else they're asking for. I don't know what you initially filed in the beginning. When I talk with people during the consultation, I have them send me a copy of what was filed. I talk a lot about supporting documents and making sure that you keep copies. If you're going to do this without an attorney, you got to keep copies of what you file in case you need to bring in an attorney later. And to be clear, I have attorney friends who will not touch a case that they haven't filed. That, if you filed it on your own, they won't touch it, because oftentimes people don't have copies of anything. They don't know what happened in the file. They're operating blind. So that is also a risk that you take when you file on your own. But again, I don't know what they've asked for. So, a request for additional evidence, I don't always see them as bad. I think they're gifts. Now, it certainly puts us under a time crunch. There's definitely a time crunch where we have to get these documents and get them in, before the deadline, but I don't think they're inherently a bad thing. All right, we are live we're live on TikTok, we're live on in the Facebook page, on the private Facebook group. If you want access to the private Facebook group, you can click the link in the bio and request that. We're also live on the YouTube channel, across the internet, across these interwebs. I can be found at USA Visa Guru. And if you want to start working with a firm, if you want us to help you with your immigration case, all of our engagements start with a consultation. It gives me an opportunity, one, to meet you, right? So I can meet you. Two, it gives me an opportunity to dig in, ask a lot of questions, make sure that I understand what your case is, as well as what your ultimate goal is, what you are trying to achieve, and how my firm can help you get there. Let's see here. This is back on the request for further evidence. More evidence of my affidavit and say final decision. I don't know what you mean by say final decision, but affidavit, I'm assuming that's affidavit of support. I don't know. You did not say. But the affidavit of support is a document where the government can make sure that the sponsor has the ability to financially support their family member / beneficiary. And again, I don't know what they asked for in the RFE, so I don't know, again, whether it is a good or bad thing. They have asked for more information, so they feel like they don't have everything that they need. But again, you get a very limited amount of time to respond to an RFE. So if that is something that you want to work with us on, I would say click the link in the bios and set up a consultation. And then we dig into what was filed and what the government is asking for and how we get them the documentation that they need. In general, the affidavit, hold on a second. In general, the affidavit of support is used to determine by the government whether or not the sponsor, usually the U.S. citizen or the green card holder, can financially support their family member that they are sponsoring for a green card. If they cannot, if the numbers don't work, that is not the end of the case. People can get a joint sponsor and then use the income of the joint sponsor to show that they can, to show they have a joint sponsor who will help take on some of that financial responsibility for the intending immigrant. So that's kind of where we are with affidavit of support, joint sponsors. It is a thing. My clients use them, have been approved with them. So it's not something where the government looks down on it. It is a provision in the law. It is allowed. So just kind of keep that in mind. But I do not think that RFEs are always a bad thing, quite honestly. So keep that in mind. What else do we have for questions tonight, y'all? I feel like everyone's had a very long Monday. Let's see here. How can I bring a friend here permanently from Tanzania? What's the most likely way? I have no idea. Your friend and you would have to schedule a consultation. That I get that question often, y'all. That is such a broad question. And I don't think you'll understand how broad that is from our perspective. When I look at a potential case and talk to you during the consultation, I look at whether there's a family-based way to bring someone into the country. I look at whether there's an employment-based way to bring someone into the country. I go through a lot of different ways to get someone into the country that works for their individual situation. So that is an incredibly broad question, although an incredibly valid question, right? Like, you don't know what all the ways are. So it's a very valid question, but is one that really needs to be done during a consultation. That gives me an opportunity to really dig in, ask you questions, and then from there, we come up with a strategy. I just did a consultation like that today. It was for a U.S. citizen that is dating somebody who lives outside of the U.S. The person is a foreign national. But we were able to talk about what the family-based options were, if they chose to get married, if they chose not to get married, if this individual chose to try to move to the U.S. based on employment for their current company, or whether they wanted to try to get a green card based on their own, still for employment. So we looked at EB1, extraordinary ability option. We looked at EB2, national interest waiver options. But before I was able to really come up with some of these options, even for us to look at, I asked questions and I had some sense of what was going on in this individual's employment background, their employment history, their career, and where their heads were in terms of marriage. So that might be a completely different conversation for a different, for somebody else. So it's just, you've asked a very broad question. So I wanted to kind of give a little bit of flesh around that as to why I just can't say, here are your options, because I don't know, because I don't have enough facts. Okay. Hi, attorney. Hi. Is it difficult to prove a valid case? I don't know. I do not handle valid cases in my firm. I know plenty of attorneys that do. I'm just not one of them. So I don't know how hard or how difficult they are. So I'm sorry, I can't really give you a better answer than that. If someone is living in Canada, how much is the time period of petition applying in the US? Don't understand your question. How much is the time period for a petition applying in the US? So I will say this, I'm not quite sure I don't fully understand your question, but if someone is a Canadian citizen, they're coming to the US, if they're coming based on employment, they could be eligible for what we call a TN, which is a trade NAFTA visa. There are There's a treaty between the US, Canada, and Mexico that allows for the movement of folks across the border into the US when they will be working in certain professions and they hold certain academic credentials. These professions are specifically listed in the treaty. They're actually in the appendix to the treaty. So there's that. So they could be coming in as a TN. Those applications can be done literally at the border. If they're coming in on a different kind of, employment-based processing, it will totally depend on what they're coming in under. If they're marrying someone, if they're marrying a U.S. citizen, they've already married a U.S. citizen, then that's a family-based case. And so the timing is completely different there. So it really depends, again, on what they're doing. So the next question is, if a U.S. citizen applies for a sibling, so the sibling time frame is outrageous. I'm just going to be honest with you. The sibling time frame is like 15 to 20 years. U.S. citizen applying for their adult sibling is going to take forever. They're at the very bottom of the preference category, so that will take a very long time. Again, that's really a good consultation to figure out if there are other ways available for that Canadian to come into the U.S. and work, live, stay, short-term, definitely, it just kind of depends. Let me see if we've got questions over here. And again, we're live on the Facebook group, the private Facebook group, the Facebook page, and the YouTube channel and TikTok. Let's see here. I don't think I've missed any questions. So I'll give you all a little bit. If you want to pop some more questions in, I am happy to see if I can help you and answer them, and give you some good info and educate you on U.S. immigration. Otherwise, I'm going to pop off and go get some dinner. But I'm Carol Williams with Williams Immigration, boutique immigration law firm. I've been practicing for 25 years. I used to be an adjudications officer inside USCIS at headquarters. If you want to work with us, that would be great. It all starts with a consultation. You can click the link in the bio, schedule your consultation. We can then talk about your individual case, your individual facts, figure out what you're trying to achieve, come up with a strategy to help you get there. You are welcome to send a message. You can send a DM. We do check those, although we do not give legal advice through DMs. So don't get upset because I do not do that. You will have to schedule a consultation. That is how we start all of our relationships, our professional relationships with clients. Or you can call the office at 954-903-1337. All right, y'all. I don't see any more questions coming in. So this has been fun as always. Let me check my calendar. I think I'm coming back tomorrow. Yes, I shall be back tomorrow, live with you. So we'll be back again. So if you didn't get a chance to ask your question, or you were feeling a little too shy, which I totally get, we can tackle your question tomorrow. But for now, I will say have a very good, for me, it's Monday evening. Not quite sure where you are, but have a great rest of your evening or day. And we'll be back tomorrow. All right. Talk to y'all soon. Bye.